Okay, we should now be recording. And it's so wonderful to be here with you all. I'm going to share some slides, but given that this is a pretty small group, I want it to be very interactive and we can sort of stop along the way and ask questions and just chat. But I just want to be sure that you have the information, because what I will say is I am going to be providing a lot of information about these two new federal laws. They're really exciting. They're really robust. The one thing I would say is if you remember very little, it's totally fine. Just remember there are two new laws, and there's an organization that has a helpline that you can call, whose number will be all over these slides. And we're happy to talk to you about anything. So I always like to preface with that because it is going to be a lot of information. But I couldn't be more excited to be talking with you all because you are working directly with patients, with other nurses who are working with patients, and oftentimes the people who need workplace accommodations, the people who find out about that are healthcare providers and specifically nurses. So having your radar up for people who are in need of accommodations and need time and space to pump is super, super important. Okay, so I'm going to go ahead and share my screen. Can you all see a presentation? All right, let's move this into presentation mode. Okay. So you heard a little bit about a better balance. The one thing I'll note is I'm based in Washington, D.C. The organization is headquartered in New York. We have offices also in Nashville, in Denver, and New Orleans. So we're really all over the country, and we're a national organization, but have our boots on the ground in many different areas of the country. The organization, our mission is to change the law, advance the law so that people don't need to choose between caring for themselves, caring for their loved ones, and their jobs and their paychecks. So let's start with the Pregnant Workers Fairness Act. This is a new federal law. It went into effect on June 27th of 2023. I'm just curious because we're a small group. Can folks put a thumbs up if you've heard about the Pregnant Workers Fairness Act already? Okay, Taryn has. All right. Well, I'm really glad we're talking today because more people need to know about it, and every healthcare provider needs to know about it. So you all are going to be spreading the word after this, and I'm very grateful for that. So the Pregnant Workers Fairness Act is a new federal law, meaning it applies nationwide in all 50 states. And what it says, sort of in very simple terms, is that employees have a right to receive accommodations on the job for needs and limitations related to pregnancy, related to childbirth, and related to other pregnancy or childbirth related conditions. So conditions like fertility, infertility, obviously childbirth, lactation, lots of different miscarriage, a lot of different conditions relate to pregnancy. And for all of these, if someone needs a change on the job in order to stay healthy while they're pregnant or after they just gave birth or while they're undergoing treatment, then they are entitled to those, so long as it doesn't cause undue hardship on employers, meaning it's really difficult or it's really expensive. It's a fairly high bar to meet. It's employer specific. So a large employer, the undue hardship on them is going to look different than the undue hardship on a small employer. The threshold is the law applies to workers who work at workplaces with 15 or more employees. So that's kind of the baseline. People are entitled now in this country to accommodations on the job to stay healthy while they're pregnant or just gave birth or have other sort of reproductive related needs. And employers have to provide them unless it would be really, really difficult to provide them. And it's really a sea change because prior to this, you could only get accommodations if you had a pregnancy-related disability under the Americans with Disabilities Act. But that landscape is no more in the United States. So what are we talking about when we talk about reasonable accommodations? It's really broad. There is no, the law says reasonable accommodations, and that can mean a wide range of things. So that can mean anything from more rest breaks, more bathroom breaks, more food breaks, changing of an employer policy around breaks, around food, drink, rest, working indoors. So thinking about environmental consequences, right? If someone is pregnant and at higher risk for environmental factors, maybe working inside instead of outside, getting more water breaks outdoors, etc. What else can it include? Seating, right? If someone stands all day, they work in retail, being able to sit, assistance with heavy lifting. A lot of people lift over X amount of pounds, which can cause issues, we know, in pregnancy. And many healthcare providers tell people to avoid heavy lifting. And we've seen a lot of people get kicked off the job because they can't lift over a certain amount of pounds. But now accommodations for heavy lifting is an accommodation. So people need to be accommodated and be allowed to stay on the job. Moving positions. If the position itself is really hazardous, or someone works with chemicals, or is doing a really strenuous job all day, potentially moving positions, getting light duty or restructuring a job, being able to come in late, or change a schedule so people can attend prenatal appointments or postnatal appointments. All of these, and this is a non-exhaustive list. So we're just giving kind of common examples, but there is no defined list. So it's really about what the worker needs and the employer working with them to provide it. So just giving a scenario, Kiara works at a fast food restaurant. It has 25 employees. She is 3 months pregnant, and her doctor recommends that she have access to a water bottle so she can avoid dehydration. Are there any changes Kiara can ask for in the workplace to stay healthy and working? I'm going to open it up to everyone. Can Kiara ask for changes at work? Does she have legal right to ask for a change?
I would say yes.
And why, Heather?
Well, when she's pregnant. Oh, 25 employees though. I thought we said 15. Never mind. I guess she can't do it. So she has to become.
No, 15 is the minimum. 15 is the minimum.
Oh, minimum. Sorry. Okay. So yes, I think she can then. She's pregnant, and she can ask for bathroom breaks.
Amazing. Or can she ask for a water bottle? Like, would the employer have to provide that potentially?
I don't know about that.
So the answer is yes. So she can ask for multiple kinds of accommodations. So under the Pregnant Workers Fairness Act, she can ask for and receive access to water, access to bathroom breaks as a reasonable accommodation under the law. And her employer has to work with her to be able to provide the water and to provide the breaks, because it's really not going to be very difficult for an employer to provide those things. So they're not going to be able to claim, likely not going to be able to claim an exception. Okay. The other really important thing is that, again, someone doesn't need to have a problem in their pregnancy in order to receive accommodations under the Pregnant Workers Fairness Act. So what that means is that if a provider thinks that someone needs a preventative accommodation to maintain a healthy pregnancy, right? Like telling someone, okay, ask for an accommodation not to lift because we don't want you to strain yourself and then cause harm to a pregnancy, or strain yourself after childbirth. And so a preventative accommodation is also allowed under the law. And so even if someone doesn't yet have a problem, they can ask for accommodations in order to prevent a problem from arising. So preventative accommodations are really key here to the success of the PWFA. Another aspect is that, like I said, people can ask for accommodations related to their pregnancy, related to childbirth, or other conditions, including lactation, which means that under the PWFA, if someone wants to go back to work and wants to pump at work, they can ask for break time and space. And we're going to discuss another law that also passed that provides that right, but not just break time and space. They can ask for modifications to uniforms as an accommodation. We've seen women who work as police officers and, can't wear their bulletproof vests. And so they need accommodation in that way. And lots of other, it could be time off because someone has mastitis, could be an accommodation. So lots of different accommodations for lactation as well. Childbirth accommodations. This one's really important. So as folks know, there's the Family and Medical Leave Act in the US that provides people with unpaid time, after they give birth to bond with a new child. The problem is that close to half of workers in this country are not eligible for the Family and Medical Leave Act because they don't meet the eligibility requirements. They're very stringent. The Pregnant Workers Fairness Act is really important because for those who don't have FMLA, childbirth recovery can be an accommodation, meaning it's not necessarily paid, but it's job protected time off to recover from childbirth. And that's usually 6 to 8 weeks. So for someone who doesn't have leave under their employer policy, doesn't have leave under the FMLA, doesn't have paid leave under a state law, the Pregnant Workers Fairness Act is an avenue for people to get job protected time off following childbirth, because time off to recover from childbirth can be an accommodation. And if someone potentially needs more time than 6 to 8 weeks because they have postpartum depression, or they had a really physically like they had more disability involved in their, or complications involved in their childbirth, they might be able to get more than 6 to 8 weeks off to recover from childbirth as job protected time. So the law is really broad and really important for people, because we've seen people go back to work within days of giving birth because they have no access to job protected time off. This is not to say we still need a paid leave, a national paid leave law in this country, but for so many workers, they don't even have a job. Their job isn't even protected, let alone getting paid. So the Pregnant Workers Fairness Act is hugely important in that regard as well. And again, just emphasizing what we mean by conditions related to pregnancy and childbirth. That includes if someone needs accommodations related to miscarriage, related to mastitis, related to lactation, related to fertility or infertility treatments, right? If someone needs an accommodation to go to IVF related appointments, that could be an accommodation. So as you're working, with patients, really thinking through if the workplace is becoming a barrier to their health, that this is a law that could really provide protections for them. Because often the workplace is a great barrier to someone's health. Okay, so we have another scenario, and Heather was our brave person to do scenario 1, so I'm inviting others to jump in on scenario 2. So Anjali works in a fulfillment center. Let's say the fulfillment center has 100 employees, and she packs boxes and she's 6 months pregnant. She asks her boss if she can take breaks to rest and use the bathroom every hour, and if she can avoid lifting over 20 pounds. She also asks if she can take time off for prenatal appointments. Which, if any, of those accommodations should her employer make?
Would it be all of them?
Yes. I think that's really, thanks, Kara, for jumping in. I think it's really important, again, to understand that it's not that someone has the right just to one reasonable accommodation and that's it. We know that people's needs change, right? Someone might need a pregnancy-related accommodation for morning sickness in the first 3 months of their pregnancy. Then they need a different accommodation because their center of gravity is shifting in their 3rd trimester. and then they need an accommodation related to a childbirth related need, or they need a couple of accommodations at 4 months pregnant. So it's really about accommodating people at various stages of their reproductive life, and with various accommodations that they may need. So thanks, Kara, for jumping in there. So she would be entitled to rest and bathroom breaks, time off to attend prenatal appointments, and avoiding heavy lifting so that she can stay on the job and she can stay healthy. All right. So we have Kara and we have Heather who jumped in already. So given our small group, everyone will probably be participating because there's probably 4 scenarios in here. So Dolly is 35 weeks pregnant and she goes into labor unexpectedly and gives birth to her baby boy. Her boyfriend calls her work, which is a retirement home, as soon as he can and lets her manager know about the birth and that Dolly needs at least 6 weeks to heal. But Dolly's manager thinks it's a company policy that he might have to fire her for being a no-call, no-show. Can Dolly's employer fire her under this circumstance?
Absolutely not.
Taryn, I love your conviction, and that is absolutely right. So no, the employer cannot fire her. And I think the really important part to know about the Pregnant Workers Fairness Act also is that A, it protects recovery from childbirth, and B, it has anti-retaliation, anti-punishment protections for asking for and using accommodations. So not only do they have to provide the accommodations, they can't punish you for needing an accommodation. So it's really important because there are real protections here, not just for the accommodation itself, but for preserving people's jobs, preserving people's right to their same pay and promotion and all of that, and not being penalized for that. And the accommodation itself here, which is that she needs 6 weeks to recover from childbirth. So unless that would be extremely difficult or extremely expensive for them to provide that unpaid leave, she's also entitled to that unpaid leave. Okay, now we get into sort of how it works. So if a patient comes to you and says, well, how am I supposed to talk to my employer about this? No one needs to use magic words when they go to their employer. It's not like someone needs to go and say, I would like to assert my rights under the Pregnant Workers Fairness Act and ask for a reasonable accommodation. Nobody talks that way. I mean, except for lawyers who are in wonky policy land, but no real person talks that way. And they don't need to. They just need to go to their employer and say, you know, I'm pregnant and my doctor said to me, I can't lift over 20 pounds. Or they don't even need to say their doctor told them. They say, I'm pregnant and my feet are really swelling up and I need a chair to sit on. Or I'm pregnant and I'm working in 100-degree heat and I need more breaks and I need more water and I need to go inside. And that triggers what's called the interactive process. So employers are required to know that if someone is saying to them, I'm pregnant or I just gave birth and I need this change, that is the Pregnant Workers Fairness Act, and they need to work with that person to find an accommodation that works. It's also the case that people don't necessarily even need to put it in writing, although it's always helpful to put it in writing, but someone can ask their manager, someone can call their manager, someone can email. There's no prescribed way or form that people need to make the request. And I think that's really important because a lot of people can get overwhelmed when they hear the law, they hear that, you know, all of these technical terms, but none of those are needed to make the request. The employer is obligated to know that requests trigger their obligations and are required to work together with the employee in what's called an interactive process. Again, just a legal term for required to have a real human conversation to try to come up with the accommodation. Okay, here's another really big element of the Pregnant Workers Fairness Act. You all may know the Americans with Disabilities Act. And under the Americans with Disabilities Act, people can get accommodations in order to perform the essential functions of their job. And we know that a lot of times under the ADA, employers use the concept of essential functions to not provide the accommodation because they'll often say, well, even with this accommodation, you can't perform the essential functions of what your job are. And so I'm sorry, we can't give that to you. You need to go out on unpaid leave, or we're firing you, or et cetera, et cetera, et cetera. What's really cool and innovative about the Pregnant Workers Fairness Act is even if someone can't perform their essential functions, let's say lifting is an essential function, the employer under the Pregnant Workers Fairness Act has to temporarily excuse the essential function and allow the person to keep working. So they don't have to excuse it forever. It says if the person can perform that essential function in the near future, and they just can't perform it temporarily, then the employer still needs to accommodate them. So this is a really exciting development in the law, because we see so many times employers try to say, well, I'm sorry, you can't perform the essential functions, you got to go. But for the Pregnant Workers Fairness Act, if someone needs a pregnancy, childbirth related accommodation, then even if they can't perform the essential function for a temporary period, they still have to be accommodated. And again, reinforcing, can't be punished, retaliated against for needing, requesting, or using an accommodation. Okay, here's other elements that are really important. One, you can't be forced out onto unpaid leave. Like I said, the employee can ask for unpaid leave as an accommodation, but oftentimes what we see is someone wants an on-the-job accommodation, the employer doesn't want to give it, and then they push them onto unpaid leave. That is very clearly defined as a violation of the law. The second is we don't want paternalism creeping in to the law here. So the request needs to come from the employee. What we'll sometimes see is employers say, oh, you look 8 months pregnant. You probably need X, Y, or Z. So you need to accept this accommodation. That is also a violation of the law. Employers can't force people to take an accommodation that they don't want or need. The request has to come from the employee. And again, you can't be retaliated against for reporting that there's been a legal violation to, let's say, a government agency. Okay, scenario 4. Lila excitedly tells her manager that she's pregnant. Her manager seems excited as well and says, that's great. We need to make sure that baby stays safe, so no more working overtime. Lila's confused because she doesn't want to stop working overtime and actually needs the overtime pay. So can Lila's manager stop her from working overtime?
Say no.
Yeah, that's correct. Thanks, Katie, for jumping in. That's right. They cannot force her to accept an accommodation of not working overtime because she didn't ask for it, she didn't want it, and it's now against federal law to do that. Okay, now we get to how the law is enforced. So this is a law. It's not a policy. It's not a suggestion for employers. This is an obligation employers have. And if they violate the law, they will be held to account. And if they are found to have violated the law, they will need to pay large amounts of money for having violated the law. So the Equal Employment Opportunity Commission is a federal agency, and they are the agency that enforces the Pregnant Workers Fairness Act. You may know them because they also enforce the ADA. They also enforce the Civil Rights Act, which is the country's anti-discrimination law. And that is the agency that people go to file complaints if there's been a violation of the law. So people first, when it comes to the Pregnant Workers Fairness Act, if someone thinks there's been a violation, they do have to first go to the EEOC and file a charge with the EEOC. The EEOC will investigate, but there's also an opportunity after the EEOC investigates to bring and file lawsuits in court. So it's something called exhaustion, where people need to first exhaust going to the federal agency, and then they can bring a lawsuit in court. So it's important to know that. Federal government employees have their own process for filing a complaint. It's called the Office of Congressional Workplace Rights, for those of you who work with a lot of federal government employees. So they have a separate agency that funnels those violations, but still have the same access to remedies if there's been violation. And the last piece is that the EEOC has put out proposed rules, and guidance on the Pregnant Workers Fairness Act that are very detailed. So the law is sort of the baseline of what employers need to provide, but these regulations and guidance get very particular. So we just spent the last 2 months submitting lots and lots of comments on those proposed regulations. And now the EEOC is going through all those comments and going to be coming out with final regulations in the next few months, potentially as soon as the end of December. And that really helps give contour to a lot of questions that folks may have about how the law works. Okay. There's the federal law. The Federal Pregnant Workers Fairness Act applies across all 50 states. There have also been, and we have spent the last 10 years, it took 10 years to get this law passed, but we've also spent the last 10 years working on state level pregnant worker fairness acts. So in 30 states, in DC, and in 4 cities, there are Pregnant Worker Fairness Act laws on the books, and they are still on the books. The federal law is very clear that it set a floor, not a ceiling. And what's really important to remember about the state laws is that a lot of the state laws apply to smaller workplaces. So the federal law applies to workers with 15 or more employees, but let's say you're helping someone in New York State. In New York State, it applies to all employees. So employees of all sizes and independent contractors. So you really want to think about what state you're in, because depending on what state you're in, someone might have even more protections under state law or local law as well. And for instance, and it's important to look at cities too, because Philadelphia has one, but Pennsylvania doesn't. So I know, Taryn, I think you're at CHOP, but important to sort of think through also some localities have them too. And generally the states pretty much mirror the federal law as well. There's some particularities, but definitely not going to get into the weeds on this. Okay, let me pause before we get to the Pump Act, because I just threw so much. So we're a small group, and I really want to open it up to questions.
What have you been seeing happening with outdoor workers, like construction workers and farm workers?
Yeah, that's a really good question. So a couple of things. We've been working with Justice for Migrant Women on trying to get the word out, because we really want to get the word out to farm workers, warehouse workers, because a lot of warehouses aren't air conditioned and they're in really southern states where it gets extremely hot. And so we're seeing a lot around summertime, and heat is kind of the biggest issue, and needing accommodations for heat related accommodations. So time inside, extra water, extra rest, or potentially, some people wanting to work from home. I should have said that too. Work from home is a big request that we're hearing for accommodations. That's a little bit harder for people whose jobs can't be done at home, especially the types of workers I mentioned. But we are hearing about a lot of requests like that. And there was a second piece to that. Oh, the other piece, you asked about construction workers. So we've been working also with an organization that supports construction workers, and they are soon coming out with a whole reference document for healthcare providers on pregnancy and childbirth related accommodations and all the hazards that are surrounding potentially pregnancy and childbirth and construction. And I can share that once it's done with this group, because it's very technical and very specific. on ways that healthcare providers can be supporting construction workers specifically.
Thanks.
The last thing I'll say on the Pregnant Workers Fairness Act, and I might have this in a later slide, is that there are a few accommodations. The EEOC has already said that there's a few accommodations that are just so basic, like asking for more water, asking for, extra break, that really should not require a worker to get a doctor's note. Because a lot of times we see the doctor's notes as being a real barrier to people getting accommodations. And so not only have they come out with a list, but part of what we commented to the EEOC on was that we think they should strengthen that list and add many types of accommodations to the list for which employees do not need to request medical certification, because we both know it's onerous for the employee, but it's also onerous for healthcare providers. Like providers, are seeing so many patients, having to write a doctor's note or any sort of healthcare provider note takes their time as well. And so ACOG and others submitted comments to that effect, saying, please add to the list of accommodations for which people don't need to get notes, because it can really be a barrier for them. And a lot of people can't even see a healthcare provider until 6 to 8 weeks into their pregnancy or even more, but might start having symptoms and need an accommodation. And so they don't even have a provider yet necessarily. So that's just something to keep an eye out for, because if a worker comes to you and says, oh, well, they're making me get a note for X, Y, or Z, you'll want to keep special attention to that list that the EEOC comes up with, because hopefully the accommodation they're asking for is on that list, and you can just tell them, no, the government's been very clear that you don't need to get a doctor's note. I mean, feel free to write one if it's just going to make the worker's life easier, but it's really important that on that list there be, hopefully a robust number of accommodations. Any other questions before we move to the Pump Act?
I have just a quick question. And I'm sorry if I missed this, because I know there was opportunity to provide comments. Is there going to be additional opportunity to weigh in on how they are going to be kind of implementing the act, or is that kind of passed by?
So the main opportunity to weigh in on their regulations and on their guidance has passed. That was up in mid-October, but there will definitely still be opportunities, I think, for the EEOC to put out informal guidance. So they have like FAQs on their website. They're always developing fact sheets. And I think it's going to be particularly important for them to continue to hear from healthcare providers about barriers that workers are facing. So the more you can keep track of issues that are coming up and relay those to the EEOC, and we can help facilitate that. We can help facilitate conversations with the EEOC. We really want to be able to do that, because no, the window is not shut. It's just, that was like a very particular piece, but this is a new law and it's a big federal law, and they need to hear constantly about how it's working or how it's really not, if it's not working for people. So it might be more informal, but there'll definitely still be opportunities. And I would encourage folks to sort of keep track of what you're hearing and work with advocacy organizations like ours to try to relay those to the EEOC. Okay, I'm going to move to the Pump Act, which is another new federal law. And what the Pump Act does is to expand the right to receive reasonable break time and a clean private space to express milk to nearly 9 million more workers who were not covered under a 2010 law that required employers to provide this break time and space. And this law is also already in effect. It went into effect last December. And the new workers that are covered are people like teachers, registered nurses. So this is also important for your colleagues, because now they have this right as well. And I have to say, We do hear from a lot of people in healthcare who are facing their own barriers to getting accommodations. So it's important both to think of this from the perspective of your patients, but also your own colleagues and workforce, farm workers, and many others. And the protections are for up to 1 year following the birth of the employee's child. The thing I want to stress about that protection, though, is that, like we said, the Pregnant Workers Fairness Act also provides for lactation accommodations, which can include break time and space. And so if someone wants to keep pumping for after a year after the birth, the Pump Act might not apply anymore, but they could potentially keep doing that under the Pregnant Workers Fairness Act. So you have these two laws kind of working together to support workers who are lactating. A big difference between the Pump Act and the Pregnant Workers Fairness Act: the Pump Act applies to employers of all sizes. So no matter the size of the workplace, it applies to all workers. There is a similar undue hardship exemption for employers with fewer than 50 employees. But again, an undue hardship exemption is not an exemption. It's a defense that employers can claim and say it would be too difficult or too expensive for us to provide the break time and space, but it is not a wholesale exemption. And we see this too often, that employers say, well, I don't need to provide it because I have an exemption. No, they don't. They just can claim that it would be very difficult or very expensive. But that is the Department of Labor, which enforces this law, it's government, so different agencies enforce different laws. But it's really important that people know that this is not an exemption. It applies to employers of all sizes. And even more importantly, too, employers with 50 or more employees, so like a larger employer, cannot claim an exemption of any kind. They have to provide break time and space to lactating workers, full stop. They cannot claim an exemption. They can't say it's too difficult. They must provide that time. So any employer over 50, they can't say, oh, it's too difficult, because these people have the full right to break time and space, full stop. There are certain employees of rail carriers and motor coaches for whom the law will go into effect in December of 2025, 2 years from now. And unfortunately, the law does not apply to flight attendants and pilots. The airline industry fought very hard to get those folks excluded. We are working very hard to try to get them included in various other ways, but it is important to know that flight attendants and pilots are still not covered by the Pump Act. However, they are covered by the Pregnant Workers Fairness Act, so potentially could get break time and space under that law.
As a former flight attendant, I find that atrocious. That they fought against that, but it doesn't surprise me because of the system. And I know this is being recorded, but I just had to speak up. I'm like, that's crazy that they're not supporting it. There are ways to make accommodations for flight attendants to pump. Pilots might be a little bit more challenging because the cockpit and the actual physical space. But wow.
Yeah, it was a very long, very hard fought battle. And I don't know if you were part of one of the unions, so AFA, Association for Flight Attendants, they have been extremely supportive. They fought very hard to get flight attendants covered and pilots, the pilots union. So the unions were all incredibly supportive. And they are actually still working to try to get some regulations guidance into the FAA reauthorization. If you're interested in this, Heather, just sort of from an aside, I'm happy to put you in touch with AFA, who's working on this and is a really amazing partner in this work. And we're really heroic. And we were grateful to them that they didn't allow the airlines to stop the whole bill from not passing, and ensured that, at least all these other millions of workers could get the protections.
Well, I certainly am happy to share anything with my community of friends who are still flight attendants to support this. That would absolutely, and I'm sure they're involved in some way, but they may not also know.
Yeah.
So but yes, if you share anything that you have that I can help to stoke up some support.
I will. That's great. Thank you. So just quickly on the Pump Act, the law doesn't require that the time be paid unless you're doing it on a regular paid break. But two important things. One, if someone is continuing to pump while they're working, so if they're just at their desk and continuing to type on a laptop, they have to still be paid. And salaried workers cannot have the DOL has been pretty clear that they can't have pay reduced while they're pumping as well. So that's just another feature. The big difference also with the Pump Act is that although you can file a complaint with the Department of Labor, you don't have to first go to the Department of Labor if you want to bring a lawsuit. You can go straight to court to bring a lawsuit for a violation of break time and space under the Pump Act. Like I mentioned with the PWFA, you first have to go to the EEOC before you can bring a lawsuit. That's not the case with the Pump Act. There are some particular rules, which I'm not going to go into because it's too nitty gritty, but that's just sort of a difference to know between the Pump Act and the Pregnant Workers Fairness Act. Okay, I think this is our last scenario, or maybe second to last. So Tatiana is pregnant and tells HR that she plans to breastfeed and will need a place to pump when she returns from maternity leave. HR tells her that they don't have a lactation room, so she'll have to pump in the office where two secretaries sit, and if she wants privacy, she'll have to wait until they go on their lunch break. Can HR have her pump under those circumstances? Katie, I see you shaking your head.
I don't think so, because you need to be in a private space, correct?
Correct.
Yeah.
Correct. So thank you, Katie. The main issue here is that being forced to pump in an office where two other people are is not a private space, and the space has to be private. What HR often says, or employers often say, is, well, we don't have a room. Well, the law doesn't require you to have a dedicated lactation room, although that's wonderful. We encourage all employers to have that if they can, but it's sort of an easy way to be dismissive. But there's so many creative ways that employers can comply with the law that they really have to work with employees to figure out a space. The other piece that's really important here is that they wanted Tatiana to wait until they go on their lunch break to pump if they want a space. The law is very clear that employers need to provide the space each time the employee needs the break. So employers cannot set the schedule for pumping breaks for the worker, because that is not how the body works. The body is not just going to be like, oh, well, my boss says I need to pump at X, Y, or Z time. No, if the worker needs to pump, they need to pump. And so it really needs to be on the worker's schedule. And the law is clear on that, and the DOL is clear on that. Okay, I think I did have one more. So Alex works for a small business with 10 employees. She has been breastfeeding her child and pumping at work for about 4 months when her manager tells her that a coworker complained about her taking pumping breaks. So they want her to stop in fairness to the other employees. What are Alex's rights?
She can continue if she wants to.
Exactly. She is entitled to continue taking the breaks as needed, regardless of her coworker's complaint. Hopefully this law is a paradigm shift, right? To get more comfortable with people pumping at work. And her employer has to provide the breaks. If a customer is uncomfortable, if a coworker is uncomfortable, they need to sort that out because she is entitled to her breaks. It's important to know that because she has 10 employees at her workplace, the Pump Act covers her, but the Pregnant Workers Fairness Act doesn't. But I'm going to throw in an additional question. How could a Pregnant Workers Fairness Act potentially apply to Alex?
If she wanted to continue pumping after a year?
Yeah. Are there any sort of pregnancy postpartum accommodation laws that could apply to her, even though the federal Pregnant Workers Fairness Act doesn't?
Oh.
This is Heather. I don't think so. I thought that was a no, but am I wrong?
Well, there could be a state law that applies to her.
Right.
So that's a key feature, is even if the federal Pregnant Workers Fairness Act doesn't apply, you want to make sure to think about what state the worker's in and whether there's a state level law that covers smaller workplaces. Sorry, I just threw that in there. So I appreciate everyone participating. So again, just like the Pregnant Workers Fairness Act, the PUMP Act also just sets the floor for federal law. And there are states that also have break time and space laws that still apply. So you want to think about the federal law, and there could be state laws. And that's just helpful because it's also telling employers, hey, this is a really important law. There's both a federal law and there's a state law that covers this. Like, this is a real protection you got to pay attention to. Okay, so what as health providers can you be doing to support patients and clients and colleagues? I'll add colleagues to this list. Educate, right? We started this call. So many people have not heard about this law. It's very common, and it's a new law, and we're all hearing a million pieces of news every day and working and trying to live our lives, but we really need to educate everyone about the Pregnant Workers Fairness Act and the PUMP Act. So as much as you can spread the word, tell colleagues about it, tell patients about it, tell social workers about it, anyone who's really interfacing with people who would need these protections, please do so. I'm going to share a bunch of resources at the end. Please share those out, and really encourage people to ask for what they need for at work. So much of this is born of people having fear about asking for what they need because they think they're going to be punished. But we now have real rights that people can't be punished for. And I know it's scary for people to ask for what they need, but that's why the laws here is to bring about this change so that people have the backing of real rights to be able to get what they need. We spoke a little bit about doctor's notes and how the EEOC is going to be providing further clarity on that, but just something to know for when you do write notes is it's really good to be very specific about what the person needs. Really try to think about the least restrictive accommodation that's necessary, because often doctors will write these like very broad notes which aren't exactly what, and I say doctors, I really mean healthcare providers. The law is very specific that notes can come from a wide range of healthcare providers. And if a patient is asking for the note, if a provider is writing a note that says, well, they really shouldn't lift over 10 pounds and they shouldn't do X, Y, or Z, but it's not really necessary, that could present problems for the employee, because then the employer can come back and say, well, you had 4 things that your provider said you couldn't do, and so we can't accommodate these million things, when really what the person maybe needed was just they can't lift over 30 pounds. It's also really helpful to say how long you anticipate the person's going to need an accommodation for. So, if the person really you think is only going to need it for a few months, that can be really helpful, because it's just another way for an employer to be able to plan with the worker, and not be able to so readily dismiss someone's accommodation as being too difficult. Okay, getting to resources. So A Better Balance has created a whole Know Your Rights landing page, which provides a lot of the information that I provided here today. It's called Know Your Rights, Pregnant and Postpartum Workers. And we have a whole range of resources. We have template accommodation notes. We have a template note that just explains the law if someone wants to bring that to their employer. We have all different types of examples of accommodations. We have all these really exciting guides that we created with our partners at Center for Work-Life Law on how to talk to your boss about being pregnant and needing accommodation, how to talk to your boss about getting lactation accommodations at work, and really kind of going through and hand-holding of how to have this conversation, when to have this conversation, what you can say, how to sort of smooth over these requests, and make it a really ease the process. So all sorts of information available. And I think this is really most important. We have a legal helpline that is staffed by attorneys, where people can call with questions about their particular situation. So my colleagues spend a lot of time just talking to folks about their individual situations and trying to help provide information that can be helpful for their particular need. So again, this is our free and confidential legal helpline. We're not a government entity, so sometimes folks, you know, have a little bit more hesitation calling the government. We are not the government, we're a nonprofit. And so we talk to people, it's free, it's confidential. We never talk to employers unless it's very clear that we have consent from the employee to talk to the employer. We don't ask about immigration status. The helpline's available in English and Spanish. And we're really here to support folks and are at the ready to do that. And I think that is the end of my slides there. So I'm going to take that away and then open it up to any last questions that folks have. And let me see if I'm missing any in the chat. No.
Thank you. That was super helpful. I really appreciate all the details. And we look forward to sharing the video with our membership and having it as a resource on our advocacy page. So we will make sure this gets out and share. So thank you. Great information.
Thank you so much, Heather. Really appreciate you sharing this out more broadly.
Absolutely. And we'll also make sure it goes to all of our academic program leaders. So all of the folks that run women's health nurse practitioner programs and our board who may be not working in WHNP programs, but nursing, so that it also gets out further. And we'll look at making a little infographic as well to promote it, to drive people back to the recording and the information, and list your website as a resource.
Fantastic. Thank you so much.
My pleasure. Thank you.
Well, thank you all for having me. I know this is a lot of information. Really hope it was useful, and just sending a lot of gratitude to help get the word out and make sure everyone knows about these new and really exciting rights.
And thank you so much, Sarah, for that presentation. That was really informative. And Beth, I know you had to you hopped in late, but we have been recording. So
thank you so much.
Yeah, please catch up with the recording. That'd be fantastic. And yeah, Sarah, if there's anything we can share with the other members that weren't able to join the call, please do. But yeah, thank you again for joining us. And we have a couple more agenda items before we close. But I will first give kind of environmental policy updates, and Sue is not able to be on the call. But she asked me to just share some updates of what's happening kind of regulatory and policy wise. And I would say it's kind of in this waiting pattern. EPA has, thanks, Sarah. Have a good one. EPA has a pattern in terms of EPA. They have some regulations that they put out, proposed rules, and then they'll be working on finalization. We just don't have timing yet. I think a lot of stuff's going to be finalized by spring of next year. But I think a couple things that we're hearing is there is going to be finalizing of the methane regulations. And so I think we're going to see something proposed likely in end of November, early December. We'll also likely be seeing something regarding an announcement on particulate matter standards. We're thinking that they're not going to be updating the standards, but we just, we're waiting to see, and then we'll respond accordingly. And then the other thing I just wanted to share is that Annie does have a Clean Cars petition that we are trying to circulate, just asking the administration to finalize the strongest possible standards as quickly as possible. So if folks can share that with their network, that would be really helpful. But with that, I think it's, again, just a wait and see. And then we will keep folks posted when there's opportunities to engage. And then the last piece of the agenda, Sue just wanted to kind of have me give you an update for how we're looking at calls for 2024. And so we will be still keeping the same meeting time in date, but we're going to be scheduling those a year out so that folks will have those calendar invites. And I think we're going to be doing every other month. But just know that meeting schedule will be coming at the beginning of the year, the new year. And yeah, so I think that's all, unless folks have anything additional to share. I think we can wrap early. I don't know if there's anything from the MPWH side. I know Heather had hopped off and maybe she didn't join back, but
no, but thank you so much for your time and sharing your expertise today.
All right. Thank you so much for helping us with the call, and thanks, Taryn, for joining.